Good afternoon.
Afternoon, Judge.
Afternoon, Your Honor.
All right, looks like we have everybody we need. All right, we'll go on the record. This is in the District Court of Greenwood County, Kansas. Case is entitled in the matter of the paternity of NJW by and through Tanner Whittaker, petitioner versus Danica Baker, respondent. Case number 23 DM 300005. Would counsel announce appearances, please?
Susie Locke on behalf of the petitioner Tanner Whittaker, who appears in my office.
Your Honor, Darren Patterson appear on behalf of the respondent, Danica Baker. Ms. Baker does appear with me in my office.
All right. We were last here on December 15th. At that time, Ms. Locke, you were absent. Another attorney was filling in for you. It was determined that the case would need to be set over to have you present. There's two motions currently before the court. One is a motion to disqualify petitioner's attorney. The other is the motion to set aside ex parte temporary orders. It was determined we'd need to resolve the motion to disqualify petitioner's attorney first. So we'll take that motion up first. Mr. Patterson, are you ready to proceed?
Yes, Your Honor, I would ask to start with an opening statement.
All right. And Ms. Locke, are you ready to proceed?
Yes, Your Honor.
All right. All right. Go ahead, Mr. Patterson.
Thank you, Judge. Your Honor, this is a motion that I can tell the court I've never filed in 30 years of practice. So it is a work in progress, learning how this should be argued. I can tell the court that the research has led me to sending over some rules, a case and statute to the court for purposes of argument. And the argument that I am presenting to the court that supports the request for a disqualification of Ms. Locke is that under the rules of professional responsibility, Rule 1.9A is the relevant rule that applies here. I have provided the court a copy of that, which is marked as Exhibit G, along with a case that is marked as Exhibit H, that case being the Eldon Crispins versus Coastal Refining and Marketing case. That case deals specifically with Rule 1.9A. And that's why that case is very important for making a decision in this case. That case does set out the requirements for this court and what this court would need to determine and find for the purposes of the motion. And specifically, the first thing the court would need to determine is whether there was an attorney-client relationship and whether there was that relationship and that Ms. Patrick was a former client under those terms. I would tell the court, as case law has told us, as rules have told us, it doesn't take money changing hands to form an attorney-client relationship. That relationship can be formed at the outset of just a meeting, the initial meeting between a possible client. The attorney-client relationship can be formed that quick when no money's even been exchanged yet. So the question is, in this case, did Ms. Baker believe that she had formed that attorney-client relationship? What did she base that on? And the court would then have to determine whether that relationship existed. Was she a former client? And then the second thing the court would have to determine is, was the subject matter that the previous relationship was about, is it substantially similar to the subject matter that the court has before it today, that Ms. Locke would then be opposing Ms. Baker on? Judge, the subject matter today, of course, and in this case, has to do with child custody, residency, parenting time. The subject matter in the previous case had to do with custody, residency, and parenting time. It's pretty substantially similar, and the facts you're going to find are that previously Ms. Baker, Mr. Whittaker were in a relationship where for about 6 years where they resided together, that Mr. Whittaker had a child, that during the time that Ms. Baker and Mr. Whittaker resided together, that Mr. Whittaker started an action with his ex-wife for purpose of wanting to get residency change or modifications, that you're going to find that Ms. Baker was intimately involved in that, was the one who found Ms. Locke, attended the initial meetings together with Mr. Whittaker and herself, the child, and Ms. Locke, that she then attended further meetings after that as the discussions were had about the relationship my client had with Mr. Whittaker, the home they lived in, the home environment, everything about them and the advice given by Ms. Locke was towards both of them. My client is going to tell the court she felt like she was being advised by Ms. Locke as a client living in the home after the same thing as Mr. Whittaker. So these are things the court's going to find. Why I think that's important and why I provided the court with an additional case, which I provided as Exhibit F. It's not controlling by any means. I'm going to be the first to state that. But what is unusual and maybe a little bit tougher about this one is that I could not find any Kansas cases where there was a motion to disqualify in a domestic case. I'm not for sure why. I had to go outside of our jurisdiction to even locate something that was at all related to family law, matrimonial law, to see what kind of rulings were out there. In this case of Lyons versus Lyons, where that's bait stamp mark page 14, they do note that there should be added caution. That's especially pertinent to matrimonial cases, that the described dangers of offensive use of prior confidential information are exacerbated when an attorney who has represented the family unit subsequently represents one of the parties in the matrimonial action, which is exactly what we have here, where my client felt like there was a family unit, and the court's going to find that that's the issue the court has to determine is whether there was this family unit being advised to, was there attorney-client relationship, and is it substantially similar issues before the court, and it was. Once the court gets past those two things, though, this case in Crispin's tells the court, that's it, we're done. That the actual confidences, the actual things that were actually said are not relevant because it's irrebuttable presumption after that Ms. Locke would have to be disqualified. So, Judge, we believe that you're going to hear that there was an attorney-client relationship. A family unit was being advised on how to proceed on this, and that it is I don't even know there has to be testimony about the substantial similarity of issues because the court understands what the issues are here, and then also in another case that's custody related, those are substantially related. So that's what we believe the court's going to hear today, and I'm prepared to have my client testify concerning those issues.
Thank you, Mr. Patterson. Ms. Locke, do you have an opening statement?
Yes, Your Honor. It appears that Mr. Patterson is conceding that this is not a concurrent relationship. And so I will disregard any argument on Rule 1.7a that discusses a concurrent client relationship. If in fact I formed an attorney-client relationship with Ms. Baker, I'm not clear on when that relationship was broken for it not to be a concurrent client relationship. But nevertheless, Your Honor, I do not believe that the court will be able to find that there was any sort of attorney-client relationship. Even if the court does make that finding, I do not believe that the court will be able to determine that this matter is substantially related or the same as the prior matter with Mr. Whittaker. The court should note that Mr. Patterson appears to be saying that because a case involves child custody, it's substantially related. This is two different sets of parents. There's nothing before the court that demonstrates what the prior case was about. But we will show the court today that that prior case was about establishing a holiday schedule and child support, neither of which relate to the child at issue. In this case, Ms. Baker is not the parent to that other child. But more importantly, Your Honor, Ms. Baker filed 2 PFAs against my client and lost both of those PFAs. They were dismissed. And now she did not make this challenge in either of those cases. And now she's challenging my ability to represent Mr. Whittaker in this case. This case was pending during both of those PFA matters. The case law is very clear that motions to disqualify should be reviewed with extreme caution because they're often used to harass the opposing party. Mr. Whittaker should be free to select his counsel, just like he did in his prior action. He should be allowed to have representation that he trusts, that's knowledgeable about his case, and should be comfortable and confident in that. This is just a tactic for Ms. Baker to continue to disrupt this matter and distract the court from what's really at issue here, which is a minor child and a parenting schedule. In my motion, I stated that the respondent has already acknowledged that my client is the father of this child, so paternity really is not at issue. It's parenting time, custody, and residency. And we would ask the court at the end of whatever evidence is put on today to find that Ms. Baker's motion is exactly that, an attempt to harass my client further. And we will ask that attorney fees be awarded in having to respond and be here today because we believe that the motion is improper, that no attorney-client relationship existed. And even if for some reason the court found that one did exist, that this matter is not substantially related or the same, and therefore does not rise to the level of a disqualification. Thank you, Your Honor.
Thank you, Ms. Locke. All right, Mr. Patterson, you may proceed on the motion.
And Judge, I do want to, I guess, bring up one issue that I'm just wanting to, I guess, address before we get to it, if we get to it at all. I know that my client's going to testify. It could be that Mr. Whittaker might testify, but I just want to have it, I guess, understood up front that Ms. Locke is not going to provide testimony, that the court would disregard her factual statements that she may provide. As the court knows, attorney's comments are just that. They're not comments. They're not evidence, though. We'll get into that thing that, again, in 30 years, it doesn't come up very often, where an attorney as a witness and an attorney can't be a witness in the same case that they're advocating on. So I just want to make sure that that is expressed ahead of time, that I'm not expecting that facts be provided by Ms. Locke unless she's going to have another attorney enter for purposes of this hearing. But otherwise, I'm ready to call my client if that's not an issue.
Ms. Locke, do you wish to respond?
I don't believe it'll be an issue, Your Honor. The credibility of the witness and the statements should be clear in my cross-examination.
All right. Thank you, Ms. Locke. Mr. Patterson, you may proceed.
Your Honor, I'd call Danica Baker.
Ms. Baker, if you could please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Patterson, you may proceed.
Please state your name for the record.
Danica Baker,
And Ms. Baker, what town do you currently live in?
Eureka.
And can you tell us how you know Tanner Whittaker?
He is my child's father. I was recently in a relationship for 6 years with.
And you just stated that it was a 6-year relationship. So this is 2023. Approximately what year did that relationship start?
2017.
Okay. And when the relationship started, did you have any children yourself?
No.
Did Mr. Whittaker have any children?
Yes.
And what's the name? What's his child's name?
His son,
Yes.
Carson.
And how old is Carson now?
He's 9.
So he would have been 6 years ago about 3.
3.
Okay. When you entered the relationship with Mr. Whittaker, how long was it until you two began residing together?
A couple months.
Okay. And did you two then reside together during those 6 years?
Yes.
Tell the court about his son and your interactions with his son.
Objection, Your Honor. What is the relevance of this history of Mr. Whittaker's child?
Judge, it has to do with the issues before the court here in this case, as well as how substantially similar they are to that case.
I'll allow it.
So again, during those 6 years, how would you describe your relationship interactions with his son?
I was a mother figure to him. I was a parent to him. I took care of him as a child of my own.
Okay. Did you know his mom?
Yes.
And at some point during the 6 years that you were with Mr. Whittaker, was there some court filings heard by a court?
Yes.
Do you remember approximately how long ago those court filings were in their case?
Maybe less than a year ago.
Okay, so fairly recent. And do you know what county those court filings were in?
Greenwood.
Now, did Mr. Whittaker file the first set of motions or not?
He had received child support paperwork in the mail, and that's when he had wanted to go a week on, a week off with his son. And so when we met with Susie, that's what he had discussed was.
Okay, well, let me ask you some more questions about that. Okay, so he received some motions asking to have child support modified?
Yes.
And his reaction to that was, you said he wanted what other changes?
Doing a week on, a week off custody modification and getting the holiday schedule.
Okay. And was that something you and Mr. Whittaker had discussed prior to even seeing an attorney about that?
Yes.
And what was the parenting time that he was receiving up to that point?
The Saturday to Wednesday and then Sunday to Wednesday every other week, what we are currently doing right now.
Okay. And after he received those papers, was it discussed between you and him the need to get an attorney?
Yes.
And how was that accomplished to find an attorney?
I made some calls around. I had consulted with my mom, who had given me Susie's information. I contacted Susie's office and I made the consultation appointment.
And following making that consultation appointment, what did you and Mr. Whittaker do?
We went to the consultation appointment together with our daughter was present.
Okay, and let's talk about your daughter. What is your daughter's name?
Nora,
And how old is Nora?
she is 5.
And you said that for the consultation with Miss Locke, all 3 of you went.
Yes,
Why was it your daughter went with you?
I'm not sure.
So can you tell the court what happened when you showed up at Miss Locke's office?
We had went back to a conference room, whereas she sat across the table from the both of us and started discussions as to everything that was going on and what had brought him in. Therefore, discussions had led into where communication was between her and I and her and him and the 3 of us, being as we had went in together as a family unit.
Okay. And what was being, well, let me ask it this way. As the discussion progressed, what was being asked of Miss Locke to counter with or file with?
Objection, Your Honor. This calls for hearsay testimony. If I'm not able to testify and not available to testify, anything that I said to Miss Baker is hearsay.
And poorly worded, Judge, I'm not asking my client to say what Miss Locke said, so I will restate it, Your Honor.
All right, thank you, Mr. Patterson.
What I'm asking you, Miss Baker, is what were you and Mr. Whittaker asking Miss Locke to do?
He had went in, taken the child support paperwork in, and that's when it was in to discuss that with her and discuss the week on, week off custody arrangement and the holiday schedule.
Okay. And did you provide, were you an active participant in this discussion?
Yes.
And what information were you providing to Miss Locke? You remember?
More or less, I'm home. I was the primary parent when he was working because his work schedule. I was the one who picked the kids up from school, took care of the kids after school and things like that.
And what did you receive copies of any paperwork that was filed?
No, I did not.
Okay. Were there subsequent meetings between you, Mr. Whittaker, and Miss Locke?
Just the consultation and the 3, I believe, court Zoom hearings.
Prior to any of those Zoom hearings, did you have meetings with Miss Locke?
We sat and discussed things or talked before the court began in the little office area where we did the Zoom court.
And again, what was the discussion about?
The upcoming, what we were going to be meeting about the case that day.
And what were you and Mr. Whittaker asking Miss Locke to do in that case?
Well, he's asking for the parenting time to be adjusted and child support modification and the holiday schedule.
In your discussions with Miss Locke, how did you feel about her representation?
Objection, Your Honor. Assumes facts, not in evidence.
Judge, it's not speculation. It's not assuming. I'm trying to get the facts out. I'm trying to ask my client her viewpoint.
He specifically asked about her viewpoint of my representation, but he has yet to establish that I represented Miss Baker.
These answers go to that, Judge.
Overruled.
So what was your feeling about the representation by Ms. Locke with you?
Felt like she represented us both as a family. I mean, he paid her, but we both sat in on discussions. I sat in on the court hearings, and
Was she giving advice during these consultations that you were with her?
yes,
Is it something you were listening to and going to follow?
yes,
The things that she had said, was it about your family and the home and the child?
yes.
Objection, Your Honor, that is again hearsay. Those statements are not in the record and they cannot be in the record. Mr. Patterson is assuming that I made those statements and eliciting from Ms. Baker assurances that I did make those statements.
I sustain the objection.
And Judge, that gets into the issue of attorney as a witness. I'm not sure how the court's going to be able to hear anything different than what my client is going to say, that she listened to the advice of Ms. Locke. She followed the advice of Ms. Locke. And Judge, that's the whole problem here. I guess I'm getting off track here, but that kind of relationship can be established with the opposing party in a pro se case. That's why you make a record. I didn't advise you, I'm not your attorney. I guess my questions go to the very heart of the matter and would ask to be able to have my client testify to those things.
What exactly are you wanting her to testify about?
That, and this will be the bigger one, I guess. I'm going to specifically ask my client, did Ms. Locke ever tell you that she was not your attorney? Did Ms. Locke ever tell you that she was not giving you advice? Did Ms. Locke ever specifically inform you that there was no attorney-client relationship? Lacking that gets us into a gray area.
Well, it makes it kind of difficult for me to make a decision if I can't hear any of these statements.
And these are important issues, Judge. We're talking the rules of professional ethics. These are issues this court has to hear.
I understand that. I'm just stating the dilemma that we're facing.
So I guess I would ask the court to allow me to question my client to the things I just said I wanted to ask my client.
All right, your response, Ms. Locke?
Your Honor, asking Ms. Baker about things that she alleges I never said is really the absence of hearsay. But asking her to affirm things that I did say is hearsay. So I don't think Mr. Patterson is out of bounds to say, did Ms. Locke ever tell you XYZ, if Ms. Baker's response is going to be no.
So you're not objecting to him asking her that question?
No, my objection was to him saying, did Ms. Locke tell you these things related to child custody and child custody matters? And asking her to affirm that I did or did not give her advice on those things.
Yeah, we're getting to the heart of the matter there. And again, I think that's what my client needs to testify about.
If you could just rephrase the question, Mr. Patterson.
Yes, Your Honor. First of all, Ms. Baker, let me ask you, did Ms. Locke ever advise you directly that she was not your attorney?
No.
Did she ever advise you directly that she only had one client in the room, that being Mr. Whittaker?
No.
Were you relying on the things that she was saying on how you two should conduct yourselves.
Yes.
Were you going to follow what she wanted you to do?
Yes.
Did you said you gave Miss Locke information about who you were, that you stayed home, took care of kids, is that correct?
Yes.
Um, and the relationship you had with Tanner's son, is that right?
Yes.
Now, I want to ask you that how did that stuff end in Greenwood County with Mr. Whittaker's son's case?
The last court hearing that we had attended with Judge Satterfield, mediation was brought to the table. I don't know the extent of the conversation between Tanner and his son's mother, but there was a conversation that was had there, and things seem to have been dropped, was my understanding.
Okay, so it was just dropped at some point?
That's my understanding.
Okay.
So,
Is that what Tanner told you?
more or less, both of them. I don't know the whole story.
Okay.
I knew we had something going on, and then it was done. So.
Okay. Now, after that case, then, how long was it until you and Tanner then have separated?
It's been several months.
Okay. And upon you two separating, did you believe you needed some legal help?
Yes.
So what did you do at that point for obtaining legal help?
I called around to different offices. I specifically called Susie's office and spoke with Karen, the receptionist, and asked if I would be able to get representation from them due to Tanner and I splitting up. And she had told me on the phone, no, that it was a conflict of interest.
Okay. And you also filed some PFA cases, is that correct?
Yes.
Did you have an attorney on those?
No.
Did you have, well, let me ask it this way. You did have a hearing on the PFA in Greenwood County, correct?
Yes.
And that was with Judge Webster, is that correct?
Yes.
Who was the attorney that was on the opposing side?
Susie Locke.
And what was going through your mind at that time when you saw Susie Locke on the other side?
It was very uncomfortable seeing how I had sat in on court hearings with her and Tanner, and I had sat in on a consultation with her, and I had felt like I had had some type of relationship with her to be sitting on the other side of it and her coming after me.
Felt betrayed?
A little bit.
Had you talked to an attorney previous to that about this feeling you had about Susie being on the other side in that case?
No.
Would it be true to say I'm the first attorney that you have discussed that with?
Yes.
Had anybody previously said that you should file a motion, get her off the cases, PFAs, whatever?
No.
And are you doing this to try and slow down this paternity case?
No.
Do you want to slow down this paternity case?
No. If anything, I want answers and to move forward.
Okay, so you're not, this isn't some tactic
No.
you're trying. Now, issues that were discussed in that case with Ms. Locke about your care in the home and stuff. Is that some of the things, do you believe it's the same things that's going on in this case?
Yes.
Custody, residency?
Child support, yes.
Okay. And what are you asking the court to find here today as it pertains to Ms. Locke?
Find that there was a prior relationship between the three of us or her and I, because I sat and had conversations with her, discussions with her, personal things with her. Our daughter was present in the room for the consultation. So I felt like there was an established relationship already there.
How old was your daughter then?
4.
And you had asked to have her disqualified as Tanner Whittaker's attorney.
Yes.
No other questions, Judge?
Thank you, Mr. Patterson. Cross-examination, Ms. Locke.
Thank you, Your Honor. Miss Whittaker, are you Carson's mom? Or Miss Baker, I apologize.
No.
And were you and Mr. Whittaker married?
No.
You stated that you established a consultation appointment. That appointment was for Tanner Whittaker, correct?
Yes.
It was related to Tanner Whittaker's obligation to pay child support, correct?
Yes.
And at that meeting, you and Mr. Whittaker were present, correct?
Correct.
And I established some ground rules during that meeting, correct?
Correct.
One of those ground rules being that Mr. Whittaker was my client.
I don't recall.
Another ground rule being that I would be representing Mr. Whittaker.
I don't recall those discussions ever being made.
And you stated that Mr. Whittaker was asking for a parenting time adjustment, correct?
Correct.
With his son.
Correct.
And that parenting time adjustment would be between Mr. Whittaker and Miss Smith.
Correct.
Your Honor, we would ask the court to take judicial notice of the proceeding in Greenwood County. That is case number 2015 DM10.
No objection.
The court will take judicial notice of Greenwood County case 2015 DM10.
And Miss Whittaker, you stated that, or sorry, Miss Baker. I keep doing that. Miss Baker, you stated that you didn't know what the outcome of those requests were, correct?
I don't know what she's asking.
The request to modify parenting time in custody, you don't know what the ultimate outcome of those requests were, is that right?
No, I do not. I know nothing changed, but I don't know the outcome.
Are you familiar with the rules of professional conduct for attorneys?
No.
Do you think Mr. Whittaker knows the outcome of that case?
Yes.
Do you think Mr. Whittaker understands how child custody was modified?
Yes.
Do you think Mr. Whittaker understands how child support was modified?
Yes.
If you were in fact my client, wouldn't I have had the same obligation to inform you of those changes as a result of that attorney-client relationship?
No, not necessarily.
And you stated that I gave you advice. What specific advice did I provide you?
And Judge, I guess I'm going to object to that because it could call for confidences. I would tell the court that specifically in the case of Crispin versus Coastal Refining, it suggests that the actual confidences provided not be testified about. The purpose of that case was whether there was an attorney-client relationship established and whether there is a substantial, that the issues are substantially similar between the two cases, that the actual confidences or the information that was advised about those confidences are not to be testified about. In fact, I'm looking at
Your Honor, I'll withdraw the question and restate.
All right, thank you, Ms. Locke.
Ms. Baker, did I advise you how to file a paternity action?
No,
Did I advise you how to seek child support?
no,
Did I advise you how to file a PFA?
no,
Did I advise you how to get custody of your daughter?
no,
Did I advise you how to get parenting time of your daughter?
no,
Did I advise you related to personal property?
no,
Isn't it accurate that I had several meetings with Mr. Whittaker without you present?
I'm not aware of those.
Isn't it accurate that I had several phone calls with Mr. Whittaker without you present?
I'm aware I was in the same room. Yes.
You were always present for Mr. Whittaker and
No,
I?
I was not.
Isn't it accurate that any Zoom meeting that we had or Zoom hearing we had was open to the public via YouTube?
Yes.
So whether or not you were in my office, you could have participated in the hearing
Yes.
and heard the exact same statements that were made in court.
Yes.
And isn't it accurate that Mr. Whittaker and Ms. Smith did not participate in mediation?
Correct. That was his choice.
One moment, Your Honor. This case pending before this court involves a different child, correct? Your child, Nora.
Correct.
This case does not involve Ms. Smith.
Correct.
This is a different, entirely different legal dispute.
I mean, kind of.
This is establishing paternity for Nora, correct?
Correct.
And then establishing parenting time for Nora.
Correct.
Establishing child support for Nora.
Correct.
And Ms. Baker, when you called my office and you were told that there was a conflict of interest, that was because we currently and do represent Mr. Whittaker.
Correct.
No further questions for this witness, Your Honor.
Thank you, Ms. Locke. Redirect, Mr. Patterson.
Just briefly, Judge. Ms. Locke asked you questions about what this paternity case was about. You recall that?
Correct.
And is this case about the home environments of the parties, you, Mr. Whittaker?
Yes.
The care that each of you might provide?
Yes.
The day-to-day things you do with your kids?
Yes.
Were these things that Ms. Locke also asked you about when you met with her and Mr. Whittaker together on this other case?
The home life was discussed, yes.
Okay. Because it's about residency, parenting time issues.
Correct.
And you were providing information to Ms. Locke, is that right?
Correct.
And let me ask you, did you just, during this initial meeting, and did you just sit and mute and not say anything?
No.
Were you answering any questions presented to you?
It felt like more of a discussion. Yes, it was directed towards him, but I was able to speak during that time.
Prior to these Zoom hearings that you had, was there meeting time also prior to the Zoom hearings?
Couple minutes before the Zoom hearings would start, 5 minutes.
And again, were you a part of the discussions during those meetings?
Yes.
No other questions?
Any follow-up on that line of questioning, Ms. Locke?
Yes, Your Honor. Miss Baker, we never met without Mr. Whittaker present, correct?
Correct.
And any information disclosed with Mr. Whittaker in the room is information that Mr. Whittaker would have known about your home life, correct?
Correct.
Information that Mr. Whittaker can and could still share with me himself,
Correct.
notwithstanding you being present.
I'm sorry, what'd you say?
He knows the same things about the home life that you know.
Correct.
No further questions, Your Honor.
Thank you, Ms. Locke. Mr. Patterson, anything else?
No follow-up, Judge.
All right, do you have additional evidence to present, Mr. Patterson?
No, Your Honor.
Ms. Locke, do you intend to present evidence?
Your Honor, I'll call my client.
All right. You can please raise your right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You may proceed, Ms. Locke.
Thank you, Your Honor. State your name for the record.
Tanner Whittaker.
Mr. Whittaker, did we have the opportunity to first meet in 2022?
Yes.
And what was that related to?
Custody and child support. Of my son.
Of your son?
Of
What's
my son, Carson.
And it has previously been established that Miss Baker is not Carson's mom, is that correct?
Correct.
Do you recall our very first meeting?
Vaguely.
If I asked you some questions about that meeting, would you be able to recall what occurred during that meeting?
Possibly, yes.
During that meeting, did I give any admonitions or statements related to our representation?
Yes, you stated that you were representing me.
Okay. Did I acknowledge that you were my client?
Yes.
Did we have multiple meetings about your case with Carson?
Yes.
Did we have individual meetings?
Yes.
Did we have individual phone calls?
Phone calls and emails, yes.
And in your conversations with Miss Baker, did she ever express to you that I was her attorney?
No.
Did she ever express to you in any way feeling like there was an attorney-client relationship?
No.
Were you and Miss Baker close?
Close. I mean, we're in a relationship, so
Did you share most confidences with each other?
yeah.
Do you feel like that is something she would have shared with you?
Yeah.
Objection, speculation, Judge.
Sustained.
When you separated, never mind, no further questions, Your Honor.
All right, thank you, Ms. Locke. Cross-examination, Mr. Patterson.
Sir, you testified that the issues that you went to see Ms. Locke about were custody and child support. Is that correct?
Yes, changing holiday schedule and child support with my son.
And is it correct that in that initial meeting, there were a number of things discussed about your home life that included Miss Baker?
I don't recall that. We just talked about the child support order and how to go about that and getting a holiday schedule established.
Because of the child support issue, isn't that correct? You were wanting to modify the parenting time to have additional parenting time.
I wouldn't say it would be additional. It would be the same, but I wanted to modify it to a week on, a week off. Correct.
So that the child support would reflect a shared residency, which would help you on child support, correct?
No, it was still 50-50. It was just to help ease things with my work schedule so that I could spend some more time with my son.
So the parenting time was also being discussed about modifying that, correct?
Can you rephrase that, or what do you mean?
Well, let me say it this way. You stated that you were doing a parenting plan that had apparently 4 days and 4 days, and you wanted to go week to week. Is that correct?
Yeah, it was 50-50 before, and it would be 50-50 after, yes.
So that would be a change in parenting time from what it was before, correct? You're changing the time for parenting time, correct?
Changing the days. I guess I'm not following what you're asking.
Well, let me ask it this way. At one of the hearings you went to, and it sounds like the last one, that there was a discussion of putting you into some kind of mediation to hash that out, correct?
I believe the mediation was mainly for the holiday schedule because we couldn't agree on that. She had nixed the week on, week off pretty early. And considering the fact that we had had the same schedule for the past 8 years, I had basically just chalked it up as a loss, and we were going to continue with that schedule, which is what I requested to have with my daughter, your client.
Now, in the meetings when you discussed, in the meetings that Ms. Baker was present, there was discussions about the parenting time, correct?
Yes.
And isn't it correct, Ms. Locke was giving statements and advice to you two during that time?
I wouldn't know. She wasn't giving any advice. We talked about common schedules that she's dealt with in the past and what seems to work and what doesn't. There's no parenting advice given.
Ms. Baker was involved in those discussions, correct?
She was in the room with us, yes.
And actively involved in those discussions, correct?
She spoke up on some things, yes.
And you stated that you don't have a good recollection of the meeting. Isn't that what the first initial meeting? Isn't that what you said?
Yeah. And that was over a year ago.
Did Ms. Locke have you sign any documents that would indicate that you were the only client and nobody else was?
What's that? Can you repeat that again?
Did Ms. Locke have you sign any documents, or Ms. Baker sign any documents acknowledging that you were the only client, there's no other attorney-client relationship being formed?
I believe I signed documents, or a document when I took on Ms. Locke as my attorney.
Did Ms. Baker get offered to sign any documents as such?
I don't believe so. It was just for me.
No other questions?
Thank you, Mr. Patterson. Redirect, Ms. Locke.
Yes, Your Honor. Mr. Whittaker, did you sign an engagement letter?
Yes.
Does that engagement letter set forth our representation and the scope of the representation?
I believe so, yes. I don't recall exactly what it said, but yes.
And was that letter the contract forming an attorney-client relationship between you and our firm?
Us, yes.
To your knowledge, was Miss Baker mentioned in the letter?
No. My name only.
No further questions for this witness, Your Honor.
Thank you, Ms. Locke. Any follow-up on that, Mr. Patterson?
No, Your Honor.
All right, Ms. Locke, do you have additional evidence to present?
Nothing further, Your Honor, just legal argument.
All right, thank you, Ms. Locke. All right, Mr. Patterson, closing argument.
Thank you, Judge. Judge, again, referring to the Crispins versus Coastal Refining at 257 Ken 745, I would note at page 112 that they do state it's the underlying concern is the possibility or appearance of the possibility that the attorney may have received confidential information during the prior representation that would be relevant to the subsequent matter. As court knows, they call that the appearance of impropriety. The appearance that information was provided to Ms. Locke. The issues in that case concerned child custody, child residency. And as this court knows, when we start talking about those issues and KSA 233203 specifically, which I've included as Exhibit I, there are a number of factors to be included in that discussion, including the interaction and interrelationship of the child with parents, siblings, and any other person who may significantly affect the child's best interest. We're talking about the home, and that Ms. Baker was included in those conversations as a family member, that she believed that the representation of Ms. Locke was for the family in order to get the parenting time, child support and such with Mr. Whittaker's son, that at that time, as a family member in that home, she has an interest in also. She does have an interest in that being a good outcome. So she is listening, as she stated, to the statements being provided, the recommendations or advice being provided, to follow it. Further, I would tell the court that the case is pretty clear that if there is an attorney-client relationship formed and the issues are substantially similar, then we're done. It's no further. Was there an attorney-client relationship formed, Judge? Again, there doesn't have to be money provided for that to happen. My client testified, Judge, that she felt violated at the PFA hearing with Ms. Locke on the other side. She felt Ms. Locke was her attorney. That relationship is something my client felt was violated, that was formed, and Ms. Locke was violating that relationship. So, Judge, it doesn't take magic words, and again, my client does not recall any statements being made that there was not a relationship being formed. She just remembers Ms. Locke talking to them, asking her questions of a substantially similar matter, I might say.
Your Honor, I do not like to object during a closing argument, but there was never testimony elicited that I asked Ms. Baker any specific questions, and there was never any statement that she felt violated by me appearing on the PFA.
Judge, closing arguments, my client did state that she had negative feelings. I can't remember exact words when Ms. Locke appeared on the PFA. So she did state that she felt like her attorney was on the other side. I don't have a transcript in my mind to tell the court those exact words, but I'm closing arguments. I'm summing up what my client said. Further, she did state that Ms. Locke asked her a bunch of questions about her home life, her ability to help with Mr. Whittaker's son. So
that's not accurate, Your Honor. The statements were about whether or not she provided information related to her home life, not whether or not I asked her specifically questions about her home life.
Judge, I disagree, but I'll leave it to the court on remembering the facts and deciding what the facts were in the case.
All right, and just going back through my notes, what I wrote down regarding the PFA hearing is that she felt betrayed when she saw Miss Locke on the other side. So you may proceed further if you have additional closing, Mr. Patterson.
Just very briefly, Judge, I again point out the Lyons and Lyons case because there's none here in Kansas of this similar type of cases. I couldn't find any, but I think the Lyons case that I provided to the court does give that caveat of, and it's kind of common sense. It seems like that where an attorney is involved with the family in a matter, and then decides to take up one side of that family against the other part of the family, the appearance of impropriety is it just screams out. So that, Judge, I would suggest that my client has provided sufficient statements that the court can find that she believed there was an attorney-client relationship and that these are substantially similar issues and there should be a disqualification. Thank you.
Thank you, Mr. Patterson. Ms. Locke?
Thank you, Your Honor. Referring first to the Crispin's case, Crispin's very clearly states that the burden of proof under Rule 1.9a is on the party that's alleging the conflict. Ms. Baker has not met that burden here today. She has not established that there was a former attorney-client relationship, and she has not established that this matter is substantially related or the same as the prior matter on which I am representing a new client. And that is specifically stated in Crispin's, a new client. Mr. Whittaker is my client. He was my client in the prior matter, and he remains my client here today. Ms. Baker was aware of that during the prior proceeding, and she was aware of that prior to this proceeding being commenced. And she is obviously aware of that today. So there is not me representing a new client, and there is no former representation of Ms. Whittaker. Ms. Baker. This case in Crispin's goes on to set forth how the court should look at any sort of substantially related. The court does a good job of looking at how federal circuits have analyzed the rule and ultimately ask the court to establish a substantial relationship based on a case-by-case analysis and a factorial analysis. There are 6 factors that are set forth in the Crispin's case, but ultimately the Kansas court states that the district court should make a determination after considering all the facts surrounding the 2 different representations. And we ask the court to apply the factors and look at these 2 representations and find that it's not substantially related. Mr. Patterson points at one factor in the Kansas Family Law Code out of 15 factors that are considered when establishing one aspect of this case, which is parenting time. This case involves the establishment of paternity, the establishment of child custody, of child residency, parenting time, and child support. All of those issues are before the court. None of them have been affirmatively decided. Prior to my representation of Mr. Whittaker in the 2015 Greenwood County case against Ms. Smith, several of those items had already been addressed. The only items before the court were establishing a holiday schedule So a modification of parenting time to modify a holiday schedule when there was never one set forth in the original proceeding, and a modification of child support. And that modification of child support actually came from the state of Kansas because that is a Title 4D case. So again, in that case, there are different parties, it's a different child, it's a different matter completely. When the court looks at the factors in Crispin, it will find that the case did not involve the same client, same matter, same transactions. That I did not interview witnesses related to the child involved in this case here today. I never met privately with Miss Baker. I never called her to testify in any proceedings. To the extent that the other factors apply, they actually weigh against my client. They talk about the lawyer's knowledge of the former client's negotiating strategies. Miss Baker actually knows more about how I may or may not represent my clients and what type of things I might advocate for that she can use against my client in this case. Those are things that weigh in her favor and do not suggest that these matters are substantially related or that we ever had an attorney-client relationship. The court must first find that there was a former representation of this party. Miss Baker has not established that. She has not established that there was any sort of attorney-client relationship or any sort of privileged conversations that happened. Again, the existence of that relationship is a fact-based question. Miss Baker stated here on the record that she didn't even know the outcome of the case that she alleges we had an attorney-client relationship for, that she doesn't even know what occurred or what the ultimate decision was in that matter. I would have been derelict in my duties to her as my client had I not provided that information to her and had very clear and diligent representation of her in that other case. I did so with Mr. Whittaker because he was and is my
I'm
client.
going to object, Your Honor, to counsel's now testifying, not giving closing argument.
Your Honor, I'm making statements about what is required to form an attorney-client relationship and how those apply to how Miss Baker's own statements apply to the factors that are set forth in case law.
I'll overrule the objection.
Your Honor, the fact of the matter is that the court in Barragee, which is 263 Can 446, which we cited in our response to Mr. Patterson's motion, states that motions to disqualify are often disguised as attempts to divest opposing parties of their counsel of choice. The reason Miss Baker probably felt uncomfortable was because she's facing a good attorney on the other
I'm going
side.
to object again, Your
And-
Honor, as statements not in evidence. And speculation about what my client might have thought or didn't think.
Your Honor,
Go
I
ahead, Ms.
apologize.
Locke.
She made the statement that she felt betrayed, which the court already put on the record.
All right, I'll overrule the objection. You may proceed.
Motions to disqualify should be reviewed with extreme caution as they can be misused as techniques for harassment. The court, in deciding a motion to disqualify counsel, must balance several competing considerations, including the privacy of the attorney-client relationship, the prerogative of the party to choose their own counsel, and the hardships that a disqualification can impose on the parties and the entire judicial process. Whether or not the attorney-client relationships exists for any specific purpose depends on the circumstances and can be a question of fact. And as it says in the Crispin case, these matters are decided on a fact-by-fact, case-by-case basis. There are several reasons why petitioner's motion should be dismissed. It doesn't provide that an attorney-client relationship ever existed, and she cannot meet her burden of proof to meet element 1 in the Crispin case. Secondly, Your Honor, she cannot establish that this matter is substantially related to the matter in which Mr. Whittaker is now seeking counsel. Again, different parties, different child, different issues entirely. And she also can't show that Mr. Whittaker's interests are substantially adverse to her prior interests. Again, Ms. Baker testified that she is concerned about essentially the health, safety, and welfare of her child, which are the exact same concerns that Mr. Whittaker has. To the extent there is adversity, we don't even know because this matter hasn't gone forward in any way. There are just temporary orders, and ultimately there will be a parenting plan, but we are not at that stage yet. It's entirely possible that the parties will agree to all of the issues before the court, and there will be nothing to be adverse on. So, Your Honor, we are asking today that the court dismiss this motion to disqualify, find that there was no basis for filing the motion, and award fees associated with having to argue the motion now on essentially 2 different occasions, which has only further delayed these proceedings. Thank you.
Thank you, Ms. Locke. Well, the circumstances that bring us here today are extremely common in any representation in cases like these and other matters, especially domestic matters. The client comes in with a spouse, a mother, a father, a sibling. The procedure that the attorney takes at the onset of these representations has been stated here today is the attorney typically tells the person that they'll be representing that they're the client, and to make sure that the other family members or people present understand that. And it sounds like that was done here. The evidence has shown that the representation was for Mr. Whittaker, and involving the child support issues and a holiday plan regarding his son, Carson, that was from a different relationship. The representation didn't involve Miss Baker as a party, and is also common in these types of representations. Miss Baker sat in on a consultation, provided some input. Mr. Whittaker was present at any time that Miss Baker had contact with Miss Locke. Mr. Whittaker signed an engagement letter or an engagement. Was an engagement letter, is my understanding, for the representation that Miss Locke would have in the case. Miss Baker did not sign any sort of engagement letter. Miss Baker was not a participant as a witness or a party during that representation. The testimony was that she was present in the office during the Zoom proceedings in that case, and was present during discussions made before going on the record in those matters. The case that's been cited here, the Crispin's case, sets forth the procedure for disqualifying an attorney as is being asked for here. Number 1, the attorney whose disqualification is sought formally represented the party in a matter. Well, based on the factors the court just went through, the court does not find that Miss Locke represented Miss Baker during that proceeding. There were no private discussions between Miss Locke and Miss Baker. Any comments made during those meetings, Mr. Whittaker was present and could provide the same information to Miss Locke. So I don't think that the burden's been met to show that there has been a attorney-client relationship between Miss Baker and Miss Locke. The second prong, if the court even needs to go there after not making the finding in one, is whether the matter is substantially related to a matter in which the attorney now seeks to represent a new client. Again, the court will concede that the prior case and this case are similar, but the court does not find that they're substantially similar. They involve perhaps child support, parenting time, a holiday schedule. However, it involves a different child, a different party on the other side. So I don't find that even if the court were to make a finding under the first prong, that the second prong would be met either. So the request to disqualify Miss Locke is denied. I'm not going to make a finding that this request was done maliciously or in bad faith, so I'm not going to order that Miss Baker pay the attorney's fees as requested by Miss Locke. So with the court making that finding, we still have the other motion. Are you all ready to proceed on the motion to set aside the ex parte temporary orders?
Yes, Judge.
Yes, Your Honor.
All right. I'd like to take perhaps about a 5-minute break. So let's reconvene at 2:40. We'll go off record.
Angela, I'm gonna log out and log back in on a different computer. So I just wanted to give you a heads up.
Okay, thank you.
All right, we'll go back on the record. Let the record reflect the appearance of counsel and the parties. We are now ready to take up the respondent's motion to set aside ex parte temporary orders. Mr. Patterson, you may proceed.
Your Honor, as has been stated, I guess, and acknowledged, this is a paternity action. It is governed by the Kansas statutes concerning paternity and any interlocutory orders. And there's a difference between interlocutory and ex parte interlocutory. Any interlocutory orders for a paternity case are governed by KSA 23-22-24. As opposed to a divorce where interlocutory orders are governed by KSA 23-27-07. They're different. And what they allow the court to do are different. Now that's been frustrating as a practitioner for years and ever since I've been doing these kinds of cases, in that you must approach them differently. You can only ask in paternity actions at an for interlocutory orders and ex parte orders for different things as opposed to what's in a divorce case. The motion is pretty straightforward, Judge, and sets out the statute for a divorce ex parte interlocutory order. And I use it that way in that there are certain orders in 23-2707 that can be ex parte. And there are certain interlocutory orders in 23-2707 that cannot be ex parte. And it states within that statute which ones can be ex parte and which ones can't. So when it comes to a divorce action, you can get an ex parte order that jointly restrains the parties from molesting and interfering, provide for the legal custody and residency and parenting time of the minor children. That's at 23-2707 A3. And that's can be done ex parte according to 23-2707 B, where it does set out the paragraphs and above that can be done ex parte. Now, in the paternity statute, it does have interlocutory orders that can be done, but not ex parte interlocutory. Interlocutory orders, while the case is pending, while it's progressing through, there can be orders of restraint. There can be orders to confirm existing de facto, but again, not ex parte, but those are orders that can be put in place. The statute, and I would suggest statutory construction, Judge, is pretty understood and how that's read. You just read the statute. If it's plain and clear, which that statute is plain and clear when it comes to listing what can be ex parte. And that is specifically at paragraph 2 of that statute. I'm sorry, paragraph B1. B1 states interlocutory orders authorized by this section that relate to genetic testing may be issued ex parte. What it does, that language is not included at all in the paragraph above about confirming existing de facto custody and such. So that's not something that can be done ex parte. The order that was presented to the court allowed for parenting time, custody, residency, parenting time, and child support. Specifically, child support cannot be done ex parte. What you were presented, Your Honor, was an ex parte order that was fitting for a divorce case, not a paternity case. That ex parte order was illegal, and it should be set aside at the outset. And we're asking the court to find that the paternity action did not allow for that type of ex parte order, Your Honor.
Is there any
I'm sorry.
any case law that supports your position?
I'm going by the plain reading of the statute, Judge, that the plain reading is in the divorce statute. It is clear what can be ex parte. In the paternity case, it's clear also what can be ex parte. And it does not include child support. Specifically, it excludes child support as being ex parte.
And I understand that, and I believe Ms. Locke in her response conceded that point. And I understand your argument. I was just curious if there's a appellate case that addresses this exact issue that you're aware of.
And Judge, I would tell the court that setting aside the order is what we believe should happen at the outset. Does there need to be interlocutory orders that are not ex parte? Yes. And I think the court would need to make such orders now that everybody's here, and it would not be ex parte. But at the outset, it should be just stricken completely and start anew at this hearing today.
Right. And again, I understand what you're asking for. I was just curious if you're aware of a Kansas case that's addressed this exact issue.
I haven't looked that up, Judge, no.
Okay. All right, thank you, Mr. Patterson. Ms. Locke?
Sorry, Your Honor, I clicked the wrong button. Thank you. We filed a response. My motion and oral argument will follow along with that response that we provided to the court. We did file in the alternative a cross motion to establish a temporary order. And we provided that to the court as well. So first of all, Your Honor, regarding child support, I will concede that that was improper. However, it was improper against my client. He was the one that was ordered to pay child support in the temporary order. He has remitted the child support payment that was due for December. So he has been compliant with that order, even though it was not consistent with the statute. And as we are all still learning, that was a valuable lesson for me. And so if that is set aside, we would just ask that that amount that has already been paid be credited to whatever child support amount is established. Obviously, he's not contesting that child support shouldn't be established. Your Honor, the respondent in this case is asking the court to interpret KSA 23-2224. And I would say that the respondent's counsel did a good job of citing how you construe a statute, which is by the plain language of the statute when it's clear and unambiguous. The court should look at the language as it appears and give it the effect that was intended by the legislature. A statute that is being interpreted is presumed to not intend absurd consequences, but to have a reasonable operation. And when any sort of provision is doubtful, it is given a reasonable, rational, and sensible and intelligent construction. In looking at 23-22-24, there is the allowance of interlocutory orders, and there is no express prohibition of ex parte orders. Mr. Patterson read a portion of the statute, but he left out one critical word. He states that genetic testing is the only thing that is allowed ex parte. However, when you're reading subsection B1, it states that interlocutory orders authorized by this section that relate to genetic testing may be issued ex parte if, meaning that the legislature was putting additional parameters that are required, additional requirements on the individual filing ex parte to allow for genetic testing to occur ex parte. And that would be consistent with our own personal freedom protections. Genetic testing of any individual is obviously a privacy issue. And so it would be reasonable that the legislature would raise the bar on what's required to order genetic testing ex parte. Subsection A does not include any language that specifically prohibits any ex parte orders. It only points to different sections in the statute of what must be required for an interlocutory order for different provisions. One of those provisions is genetic testing. Another one of those provisions is child support. Child support can only be ordered after there is notice and a hearing, which is also consistent with our other statutes. When you're asking someone to pay some sort of amount in or pay for a child that they may not know ever existed, it's reasonable that they would be given notice and an opportunity to be heard on that issue. Here, the ex parte orders established parenting time. They established parenting time that were consistent with the party's practice, and that the petitioner believed were in the best interest of the child. When read in total, KSA 23-22-24 demonstrates that the legislature intended for the court to have discretion regarding temporary orders during the pendency of a paternity action, that the discretion becomes directive under very specific circumstances and requires additional protections of the parties when orders relate to the examination of their person or payment of support. To read the statute any other way, or in any other manner results in an absurd consequence, right? It results in a child in a relationship, especially like this, that doesn't have any sort of permanency, that doesn't have a parenting plan, with parents that are kind of left in limbo. So, Your Honor, we're asking that the court not set aside the temporary order, to set aside the order as it relates to support, as well, we have already admitted that that was improper. But alternatively, if the court finds that the ex parte temporary order must be dismissed as argued by the respondent, that the court adopt the temporary order that was properly filed in a motion by us, and allow for the parenting plan to move forward. And we did set forth that parenting plan in our cross motion. And I would stand for any questions about any of that, Your Honor.
All right, I don't have any questions at this slot. Ms. Law, well, I do have one question. I'll ask you the same question I asked Mr. Patterson. Are you aware of any Kansas cases that discuss this exact issue?
I am not, Your Honor.
Okay. I don't want to delay this too long, but I just want to take a short recess and look this over for a second before rendering a decision. So I'm going to take about 5 minutes. We're in recess. All right, we'll go back on the record. Let the record reflect the same appearances as before. Sorry for the delay. However, I did go back and read through this, and when looking at the language in 23-2224 and comparing that with 23-2707, the language is certainly more clear in KSA 23-2707 than it is in 23-2224, which is what we're dealing with here in this case as a paternity case. But upon further reading of this statute and looking at the other one, I think I agree with Mr. Patterson's argument regarding the ex parte nature of this particular order. So I am going to grant the motion to set aside the temporary orders. Now, if you all find a Kansas case that addresses this issue specifically, I'd be more than happy to take that up and reconsider. But just based on reading back through the statute, that's going to be the finding of the court. With that order being made, we do have, I know Ms. Locke has filed the motion or the alternative cross motion for temporary order. There is Mr. Patterson, did you file the proposed temporary parenting plan?
Judge, they are exhibits for today that includes our proposed temporary parenting plan, which I would tell the court we would have some further statements to the court on that proposal. And also we did submit in that exhibits a child support worksheet that we believe is appropriate, as well as a pay stub from my client. A DRA has been filed, but it's also attached as an exhibit also.
All right. Have the parties been following the the temporary order that's been in place?
Judge,
Yes.
my client was told that it is a court order till set aside. So yes, I would tell the court my client is in compliance with a order that she's presented.
All right. And that plan is a Sunday to Wednesday plan, is that correct?
Yes, Your Honor, it is consistent with the parenting plan, that my client has with his other child. So both parties were familiar with this parenting plan, and it allows the siblings to be together during Mr. Whittaker's parenting time.
And Judge, we don't think that should be the overriding, I guess, deciding point on the temporary parenting plan. And I call it temporary. We wouldn't be close to getting to a final plan without either having some type of conciliation ordered, or that we set this matter for a trial date. But in order to just have a temporary plan, we are proposing to the court, first of all, we think that, and I can have my client sworn in and testify about these things. What the court didn't receive before in the documents provided was any type of affidavit that would give the court background information on the situation concerning the child. But my client would tell the court that the breakup was sudden in this case, that the petitioner immediately moved in with somebody else who my client does not know, and has basically thrust this child into a new household with a person that takes care of this child when the petitioner is at work. And that's one thing that in our proposed order, we're asking the court to not order on a temporary basis. My client is asking that while he is working at nights, that those should not be his parenting times, that she is wanting to have the child with her when he is not available like that. Now, she's asked for his work schedule and he's refused to give it to her. So we couldn't really put details into our proposed plan because he refused to give that to her. But we are asking the court to essentially order that my client be the primary residential custodian, that he could have parenting time when he is off from work. But she still wants her weekend, or at least in every other weekend, so that she would have the entire weekend, Friday to Sunday, not just a partial weekend. Because of that situation with him moving into a home with somebody my client doesn't know, we don't think that's in the child's best interest. And that they should either see a mediator or a conciliator, or that this case should be set for a complete trial.
Your Honor, my motion to, sorry.
Go ahead, Ms. Locke.
My motion to establish temporary orders is actually the only motion that's properly before the court. We would contest nearly every statement that Mr. Patterson just made regarding any factual inferences that he's alleging. We are asking the court to adopt the parenting plan that we proposed. We do believe that that parenting plan is in the best interest of the minor child. There's nothing that would substantiate in any way that it's not, or that a shared residential custody situation is improper in this case. Additionally, Your Honor, I don't think my client is opposed to mediation or domestic conciliation. He's not sure why that would be necessary in this case, because he thinks that once a lot of this initial strain is overcome, that these parties can get along and co-parent their daughter. They've parented her together since she was born, and resided in the same house that he still resides in since she was born. We are also asking the court today, as it is not contested, to go ahead and establish paternity. It was in Mr. Patterson's response, the respondent's response, that she's not contesting paternity of the minor child. So I think a decree of paternity is appropriate, as well as adoption of our temporary order. And if the court is going to hear argument on child support, I have some clarifications on Mr. Patterson's documents and exhibits that he's provided to the court.
All right, regarding the issue of paternity, it was Miss Baker's testimony that she acknowledges that Mr. Whittaker is the father of the child. Is that correct, Mr. Patterson?
That is not in dispute, Your Honor, yes.
All right. So the court can make a finding that Mr. Whittaker is the father of the child. Mr. Patterson, have you filed a motion for temporary orders?
Your Honor, as Ms. Locke stated, if there's a motion on file, that's what we're here for today. Doesn't mean we're prohibited from arguing that. I mean, these are interlocutory orders also. These
I
are
understand that. I was just asking if there's a motion, because I don't always have access to the complete Greenwood file.
We have provided the court a motion in our exhibits. The court has had that since the last court hearing. And it's basically called a proposed parenting plan, Judge.
Okay, I see that. Miss Locke, what is your client's work schedule?
Your Honor, my client is employed by HF Sinclair. So generally speaking, he is on a 4 on, 4 off, 4 on, 4 off schedule. Those on days alternate between nights and days.
Who's the employer?
HF Sinclair, the refinery in El Dorado.
Oh. And the child's age 5?
Yes, Your Honor. She attends half-day preschool at Eureka Public Schools. I can tell the court that on my client's time when she's not at school or my client is at work, that she is watched by his family. He has significant family in the Eureka area, including his mom and grandmother
Right next door.
that live next door to him.
Is the child ever left in the care of a girlfriend or significant other?
Not on anything more than a temporary basis, like run to the grocery store or pick up another child from school or something like that.
His son stays there.
And that's disputed, Judge. My client has information different from that.
And Your Honor, if it would benefit the court, I mean, my client would agree not to ever have his significant other watch the child for any significant amount of time. He hasn't done that, and he would agree to an order that said that. Again, on a temporary basis.
I think this case is ripe for domestic conciliation. But I am going to make an order for domestic conciliation, and we will address the temporary orders, but I think that much is abundantly clear that the parties need to sit down and hash this out and quit all this other stuff and just focus on getting a plan in place. Do you all have a preference on who you use for domestic conciliation?
We'll defer to the court making the order, Judge.
Agreed, Your Honor.
All right, well, I'll order collaborative success then.
And Judge, in reference to that, I guess the only request we would have is on payment of that to consider the substantial difference in incomes. Ask the court to consider some type of percentage basis for that based upon their incomes. So that they both have a stake in it, and as I say, blood in the game. But at the same time, it's more equal as to their burden based upon their incomes that they have. And again, I provided a pay stub. We don't have any pay stubs or anything from petitioner, but we provided a pay stub and a DRA, and as well as our child support worksheet as Exhibit B, I think shows the very disparate incomes of the parties.
Your Honor, we have filed a DRA, so that was provided as a financial disclosure with the court. But in response to Mr. Patterson's request, my understanding is collaborative success will take into account the financial condition of the parties and discount one party's fees if it's appropriate. So we would ask that that be handled first by collaborative success before the court order any sharing of fees in any way that's not equal between these two parties.
I almost always just order each party pay half of the fees. And I understand, as Ms. Locke stated, that they do work on some sort of a payment scale with the parties as need be. If we need to address that down the road, just let us know. But for now, I'll order each party pay half of that. So do each of the parties live in Eureka?
Yes, Judge.
And Mr. Patterson, where does your client work?
There we are, Judge. Has technical difficulties, but she works at the high school, Judge, in Eureka.
Okay. Mr. Patterson, I'll allow you to make argument as to what you feel is an appropriate temporary order. The court's understanding we've been operating under what was the ex parte temporary order. What would your client propose that's different than what's already being followed?
Judge, my client is asking the court that she be primary residence custodian. I can tell the court if she was to provide any testimony today, she would tell the court that she has always been the primary parent to care for this child, to get the child to medical appointments, to get the child to other necessary requirements. That's even came up recently in that the child has been very sick, that my client gets the child back after these 4 days sick, take the child to the doctor. She doesn't believe the medications are being followed, so she has to take the child back to the doctor. She's asked him to do it and he refuses. So I would tell the court that she does believe that she's always been the primary caretaker, and at age 5 years old, That's the issue that we believe is most important, that she be placed back in that position. We talk about de facto parenting time. That's the interlocutory order language, the de facto. And then the final and permanent parenting plan gets done later, but under the interlocutory orders or temporary orders, it's de facto. I would tell the court when this was filed, in fact, the de facto was my client was the sole caretaker. But when they were together, it was my client who was basically the primary caretaker. So that has been the de facto parenting plan, is that my client takes care of this child on a primary basis. We would suggest that he would have parenting time when he is off from work. But again, not knowing what his schedule is, it's still hard to put that down on a paper, on a calendar for the court, so we can make such a, I guess, call it a structured parenting plan. It's a little tough for us. So I guess short of having his actual schedule in front of us, then every other weekend would be what we suggest for him if he's not working. But she would work with him on what his weekend might be. She does have concerns about that. In fact, it's not being followed, that this other girl or lady's is the one taking care of her. There's the fact that, of course, we got the 8-year-old son that's not part of this case, but I would tell the court that we believe that in this, and I'll stick to this child. This child's being left with this other person, and it's being harmful to this child. So we are asking the court that Ms. Baker be the primary residence custodian for now. They can talk to the domestic conciliator about whether that should change or not. In the orders we're asking the court to do, though, we're also asking that the court establish child support. We would, as a part of that, ask we be provided financial information as part of this order. We have not received any of that yet. We're asking for pay stubs, and now that we're towards the end of the year, we would be asking for the final pay stub of 2023, the first pay stub of 2024, as well as W-2s. We think, from my client's perspective, her belief is that it's underreported on what his income is, that overtime's not being reported. But we're using his numbers for now on our worksheet, but we're asking the court to direct that Ms. Baker receive child support guidelines of primary residential custodian, or that she be directed to pay direct expenses. I did not put in child support for another child if there is an amount. We'll concede to that. So if that needs to be put in, that's fine. The guidelines would be what the number would be once we put those things in. So we're asking the court for primary residency, that the father have something like every other weekend based upon his work schedule, and further that child support be set pursuant to the guidelines with my client paying direct expenses, and that we get financial information.
All right, thank you, Mr. Patterson. Ms. Locke?
Thank you, Your Honor. I'm going to first respond to Mr. Patterson's arguments and then walk the court through our proposal. First of all, I think it's unfortunate that factual misstatements are put on the record and aired on YouTube for people to see without an evidentiary hearing, because we would contest much of what the respondent's position is. Again, this child has never been alone for any significant amount of time with Mr. Whittaker's significant other. And so statements like that, or statements that he's not appropriate to parent, are just not accurate. And he looks forward to taking those things up in DC and hopefully avoiding an evidentiary hearing in this matter. Additionally, Your Honor, it's accurate that the respondent was the primary caregiver. That is because she did not work during their relationship. Mr. Whittaker essentially was the breadwinner for the home, and so she didn't work and she stayed home and cared for the child. And that's not uncommon, but that doesn't mean that my client cannot parent the child, or doesn't know the child or have a relationship with her. And also, if the court remembers back, and we'll look back at the record, Miss Baker filed a PFA and got temporary orders on a PFA in Greenwood County, which was later dismissed, which precluded my client from seeing the child for a significant amount of time. So this case has had a series of unfortunate events that prevented my client from exercising parenting time, when he was and always has been a co-parent with Miss Baker. Additionally, Your Honor, we're a little bit confused about the position of the respondent, as what was stated on the record today is not consistent with Exhibit A. Exhibit A specifically says that the petitioner would have parenting time on his days off work. Miss Baker knows, and Mr. Whittaker and we have stated here today that he has a 4-on, 4-off schedule. Essentially, that is an equal parenting time schedule. If he had the child every day that he was off work, he would have her every other 4 days. That is not every other weekend. That is every other 4 days. Some months that means 3 weekends out of 4. Some months that means no weekends at all. It's just when those 4 days land. The reason that we asked for an equal parenting time schedule that is not consistent with the 4-on, 4-off work schedule is because that can be hard on families, the 4-on, 4-off. And it can be hard on kids to not, it's consistent every 4 days, but it's not consistent on weekdays or weekends. So the other part of the order, or the Exhibit A request for temporary parenting plan that the respondent proposes, is that the petitioner not have overnights if he's absent from the home overnight. Well, the only reason for him to be absent from the home overnight if his children aren't with him is because he's working nights. And pursuant to their proposed order, that wouldn't be during his parenting time anyway. So we don't want the court to adopt a 4-on, 4-off schedule, but that would be what was proposed by the respondent, which is inconsistent with their request today for every other weekend. And we are definitely not in support of an every other weekend schedule. We are in support of a equal parenting time schedule, which is what we have proposed. And that schedule is in our motion. And that states that the petitioner would have parenting time Sunday at 9 a.m. through Wednesday at 9 a.m. Or school drop off. And then respondent would have parenting time Wednesday at 9 or school pickup through Saturday at 9 a.m. And essentially the Saturdays are shared and alternated. And that exchanges would take place at the sheriff's office, which was a request of the respondent very early on in this case, and the parties have followed through with. And neither party has a problem, I don't think, with that if those exchanges aren't taking place at school. We also set forth a holiday schedule. To some degree, the parties have been following that holiday schedule. And again, this is the same schedule that is followed currently by my client in the other case with his other child, which allows those siblings to be together. And I agree with Mr. Patterson that that's not the only issue to consider, but it is important to consider that Nora and Carson have a sibling bond, and that bond should be allowed to continue. And again, not included in our parenting plan, but that my client is 100% okay with the court ordering today and would agree to, is that he would not have his significant other watch the child for any significant period of time during his parenting time, and that his family, if he was at work, would provide that childcare, which they did during when Miss Baker had to go to work. They would watch the child prior to this case starting. So that's not inconsistent with the parties' past practice. Regarding child support, we would ask the court to adopt our child support worksheet that has the order of $124 a month payable. Mr. Patterson's worksheet that is provided, the financial amount listed for the gross annual income is inconsistent with Ms. Baker's pay stub. It's also inconsistent with the DRA that she filed. It only includes a single child, which Mr. Patterson already spoke about. And there's also no parenting time adjustment, which we think will be appropriate after the court makes the order today. So our position on child support is either to stay a decision on that until Mr. Patterson and I can work on a worksheet together, or adopt our proposed child support worksheet. And again, Your Honor, we presented this in our motion, which the court I know has already read, but I would answer any additional questions.
So he's currently been paying in child support $124 a month.
That's correct, Your Honor.
And Judge, we would state that that's inconsistent. First of all, with my client's income, she is basically almost minimum wage when you add up her pay stub. So they have got her higher than what she makes, so that would be incorrect. Further, my client traditionally was always the one who paid direct expenses, went to the school, gave them the money, did those sort of things. And he has him down for paying direct expenses, which is not the case. They haven't done it that way traditionally. So that's where he's just trying not to pay child support is what it appears here. She is the one who does those things. She is the one who should receive the child support, Judge.
And Your Honor, she is receiving child support. And during the relationship, Ms. Baker was responsible for going and paying those things, but it was Mr. Whittaker's money that she was paying with because she did not work. So the reason why we took on him paying direct expenses, if that becomes necessary, is it was his money she was paying with before, and it would be his money that was being paid with now. He would just be the one responsible for making those payments, which he has no problem doing. But I mean, I think this is something that who's paying direct expenses and what the child's doing is something that can be taken up in DC.
All right. On a temporary basis, I'm going to order the parenting plan that's proposed in the petitioner's cross motion. I'm ordering the parties into domestic conciliation. Regarding child support, it sounds like there's still financial information that needs to be exchanged. Is that correct?
We
No,
haven't received any, Judge.
Yes, this is the first time Mr. Patterson's asked for pay stubs. We are happy to provide those. We did file a domestic relations affidavit with the court.
Okay, well, what I'm gonna do on child support, I'll order for now that he continue paying $124 a month until the parties have exchanged the financial information and put together an appropriate worksheet that reflects all of the current information that the parties have. The court will make, of course, that can always be retroactively applied. Mr. Patterson, you wanted to say something?
Judge, yes, I guess called the big issue is direct expenses. If the court's going to adopt that, that puts them at shared, understood, but my client's always been the one to pay those direct expenses, basically. Yeah, he's made the money. Well, that's why he should be paying child support too. It's the same thing that they were doing before. We're not asking the court to do anything except the same thing they were doing before. She's just always had that task and she should continue with it. So she should be ordered to pay direct expenses, Your Honor. And with that, I think we can do a child support worksheet, but that'd be a sticking issue that I don't think Ms. Locke and I would ever get sorted out.
All right, well, I'll order then that Ms. Baker pay the direct expenses. All right, any other matters that need to be addressed for purposes of I will make it in order that the minor child not be left in the care of Mr. Whittaker's significant other for a substantial period of time, and especially no overnights. Are there any other documents that need to be exchanged?
Your Honor, we would ask that that significant other thing go both ways if during this interim period, Ms. Baker enters into a relationship.
We have no objection to it being neutral language and going both ways, Judge.
That will be the order of the court.
Your Honor, my client just on the record, and it can be included in the journal entry, whichever one of us is going to journalize, would consent to an IWO being issued as soon as the child support amount is established.
Very well. All right, Ms. Locke, I'll task you with drafting the journal entry.
On both motions?
On the temporary order motion, Mr. Patterson, if you could draft the journal entry on the disqualification motion.
Yes, Judge, I can do that. And I'm sorry, Judge, I might have missed the court on the order for the setting aside the ex parte order. Is that going to be part of the one Ms. Locke's doing?
I think it should be, yes.
Okay, very good. Thank you, Judge.
And then we'll put the parties or order you all into domestic conciliation.
I can draft that order as well, Your Honor.
Okay. I don't believe I'll set a hearing at this point unless you all request one be set.
I don't think that's necessary from the petitioner's perspective.
Judge, just the quicker they get into conciliation, the better probably. So no hearings necessary at this time.
All right, and you all are aware of the local rule regarding domestic conciliation. And I'm assuming we'll advise your clients as how the process works.
Yes.
Your Honor.
All right, anything else?
Nothing from the petitioner.
Nothing further, Judge.
All right, Mr. Whittaker and Ms. Baker, I urge you all to set aside whatever differences you have and focus only on what's in the best interest of your child and putting together this parenting plan. Y'all are going to have to deal with each other for the rest of your lives, basically. So try to make this work. There's nothing further. We'll be in recess. Have a happy new year.
You too.
Thank you, Your Honor. You too.
Thank you, Judge.